A warm welcome to our /ProRevenge. We are cheating spouses who have experienced the devastation of our careers. Our inaugural Reddit post was written by Waffles Are Forever, a person with whom my wife and I have been closely acquainted for several years, practically since we relocated to a property situated in close proximity to theirs. Our families were extremely close, and our children the four of us were of a similar age and had formed a close-knit friendship. We often shared meals and vacation together. I considered Douchebag to be a brother, and my wife and Sarah were particularly close. 5 months ago, I was taken aback by the revelation of an affair between my wife and Douchebag. My wife had left her email open on our computer, and I saw an email from her to her longtime therapist. In the email, she stated that Douchebag would be joining her at an upcoming session. I was perplexed by this information. I did not understand why, if he were a friend, he would be going to her therapy sessions without my knowledge. I conducted a search and found some other emails. The therapist's records revealed that the individual in question had been attending sessions with the subject for approximately 6 weeks. A review of the mobile phone account indicated that since late summer, the two had been exchanging hundreds of text messages daily, with a peak of nearly 500 messages per day by the holidays. With regard to the holidays, the subject and the subject's partner were hosted by the couple in question. Both of our family's parents, siblings, etc. were hosted for Thanksgiving and Christmas dinner by both myself and my wife. During these occasions, it was observed that the couple in question, referred to here as Douchebag and Sarah, joined us either for dinner or after dinner on both holidays. Text records showed that throughout the entirety of their time at my wife's house celebrating with our families, my wife and Douchebag were texting each other across the room. The frequency of their communication was notable, occurring with remarkable consistency when the four of us were together. However, what I found most troubling was that they were engaging in this behavior with Sarah and me directly present. I confronted my wife with the evidence, and she acknowledged that she and the other individual had indeed developed romantic feelings for each other. I am unsure how this occurred, but I developed feelings for him, and I no longer feel the same way about you. I am sorry to say that they had gone on a school district trip together. Something had occurred in her hotel room, and things had progressed rapidly from there. She explained as I lay face down on the couch, unable to look at her, that they had already made plans to move. They proceeded to inform me of their intention to divorce me and Sarah. While they did not intend to move in together immediately due to the presence of their children, they anticipated doing so at some point in the future. The sessions with the therapist were purportedly designed to facilitate the delivery of this news to me and Sarah in a sensitive and considerate manner, given their evident concern for our well-being. It is our assumption that they had no intention of disclosing the affair and that our awareness of their feelings for one another will emerge several months hence, when they have formulated an alternative rationale for divorcing us. My wife vacated the marital residence 2 months ago, and I am still in a state of profound distress. I weep daily, and I wept while composing the initial passages of this narrative. My concern is not merely emotional. The impact on our children is a valid concern, but I also have a right to be heard when I feel wronged. In this case, I was objectively wronged, so a couple of years ago, I assisted the individual in question with his campaign materials and debate preparation. My wife, who is a known school district employee, this individual disseminated information in a manner that was perceived to be optimal. To our surprise, he was elected to the Board of Education by a narrow margin, winning by just a few dozen votes. His ascension to the board became a pivotal point in his life, as evidenced by his participation in numerous committees. This involvement ultimately led to the inception of his extramarital affair with my wife. We were frequently in attendance at school events and meetings together on weeknights and weekends. Once I became aware of the affair, I began to consider how I might retaliate. I realized that an extramarital affair between a member of the Board of Education and an employee of the school district was, at the very least, a breach of political protocol and, potentially, a violation of district policy. Furthermore, my wife was a candidate for an open administrative position, and it was widely known that she was a strong contender for the role and the accompanying salary increase. She had recently completed her master's degree in school administration at the urging of her principal. I had ample evidence of the affair, including text messages from both individuals admitting to it, text records indicating that they were texting hundreds of times a day, emails to and from therapists, and so forth. I contemplated simply emailing all of the evidence to the board. I considered disclosing the evidence to the board, but I felt that as the grieving spouse, I might not be perceived as a credible source. Instead, I devised a fictitious account of a disgruntled acquaintance who planned to attend the next board meeting and publicly shame the two individuals for their affair. I informed my wife that I attempted to dissuade this individual from attending, but was unsuccessful. I guaranteed that they would not show up and humiliate them publicly, as I expected this would lead the individual in question to conclude that the only option was for him to preemptively admit the affair to the board. The superintendent subsequently recommended that the individual resign, which he did. Sarah said that he was utterly humiliated and crushed and barely for several days following the announcement of the affair and the subsequent resignation of the individual in question, I was unable to function normally. Once the news of these events began to circulate among the relevant parties, a long-standing acquaintance of both my wife and the aforementioned individual contacted my wife to express his profound distress. He informed her that it was no longer politically expedient for her to be considered for an administrative position within the district. The position that had been earmarked for her was subsequently filled by an external candidate. This resulted in a significant degree of confusion and speculation within the district, given the widespread understanding that my wife was to be appointed to the role on the following day. However, following her being informed that she would not be receiving the promotion, my wife and I, despite the fragility of our marriage, on the occasion of our son's birthday, we took him out to breakfast. A parent stopped by our table to congratulate my wife on her new role. She proceeded to make a series of statements, after which she excused herself to go cry in the bathroom for a while. I allowed a period of approximately 2 weeks to elapse before disclosing the information to my wife. I did so just before she relocated. There was never any intention of concealing the matter from her. A disgruntled acquaintance initially threatened to expose the situation. As a result, the news has spread throughout our relatively small town, where my wife has worked for nearly 2 decades. My wife has chosen not to discuss the matter with me, but I have received information from individuals in the district who have indicated that as a result of these events, her formerly spotless reputation has taken a significant hit. The individual in question, who was previously a prominent social figure in our community and at local events, has become reclusive, rarely emerging to mow his lawn. He is soon to relocate to a less desirable townhouse, the only option within his financial means due to the child support obligations he has incurred. Despite the public humiliation, my wife and the aforementioned individual claim that they intend to attempt to reconcile their relationship. I am skeptical of their ability to do so. It would undoubtedly be entertaining to observe them together in public. I am curious whether others have similar fantasies about the potential union between Opie and Sarah. A felicitous conclusion to this tale of retribution would be a happy ending for the protagonist and her nemesis. This narrative takes place approximately 5 years ago, when the author's husband and herself were financially constrained college students with a young infant. They toiled to afford their modest accommodation. The rent for our apartment was $600 per month, which included utilities. We were pursuing our degrees while raising our child. One day, we discovered that our apartment was owned by a large company and managed by a married couple who were not above questionable practices. They had previously lived on the same street as us before our child was born. We were excited about becoming parents and did the typical thing of painting his nursery and decorating. The lease stipulated that permission was required to paint, which was duly obtained from the property manager. The husband of the couple was insistent that it would be acceptable, and, being young and naive, we did not seek written confirmation from him as he appeared to be quite relaxed about the matter. Consequently, we proceeded to paint and subsequently resumed our lives. Upon the expiration of our lease, we provided the property manager with notice of our intention to vacate the premises, as we were relocating to a residence in closer proximity to my husband's educational institution. The property manager was amenable to our request and scheduled an inspection to assess the condition of the property prior to our scheduled move-out inspection. Prior to this inspection, we specifically inquired about the paint color that would be required for repainting the nursery. The property manager, however, declined to provide this information. He declined to provide it, stating that it was unnecessary to paint since we had resided there for an extended period and the entire duplex would be repainted regardless. We proceeded with the scheduled inspection, which took place without incident. Aside from a small area of torn carpet along a seam in the doorway, the property manager deemed the condition of the house satisfactory and recommended that we receive our full deposit back, amounting to $400. A few dollars for the torn carpet seemed an acceptable compromise. We waited for several weeks for our deposit, leaving numerous messages with the property manager, only to receive false promises or no return calls at all. After over a month, we finally received a call from the property manager, who stated, "I remember this almost verbatim. Verbatim, I am unsure what your concerns are. The deductions total only $200. You will receive this amount back." He cited the painted nursery and the significant mess left behind as reasons for the deductions. I informed him that we would pursue legal action because we did not believe we owed for those reasons. The property was in pristine condition when we left. Aside from the 6, we left him a pack of beer in the fridge as a gesture of goodwill. However, just 1 hour later, he called back and informed us that our refund check had arrived by mail. We had suspected as much, as he had been trying to scam us. We installed a recording app on my phone to document the incident. We proceeded to the office to discuss the matter further. Upon inspection, the check in question was only for $200 of our deposit and did not itemize the charges. We then confronted the individual who had issued the check, eliciting the admission that he had instructed us not to pay the remaining balance and that the property appeared to be in good condition upon our departure. We then proceeded to devise a plan of action for recourse. We did not cash the check but instead sent an email to the CEO of the entire property company, copying in the property manager. The CEO responded with a detailed email that included a typed list of deductions. This list included items that we had been informed were not included in the charges. Interestingly, the CEO's calculations indicated that we were owed $230 of our deposit. However, the rationale behind issuing a check for only $200 remained unclear. In response, we began researching state regulations on security deposits and refunds. Our objective was to determine whether there were any grounds for disputing the charges. To demonstrate that the duration of our stay precluded the imposition of charges for wear and tear, such as carpet cleaning, we conducted an investigation and discovered a statute requiring landlords to return security deposit refunds and provide an itemized list of deductions within 30 days. Failure to comply with this legislation would result in the loss of the right to withhold for actual damages and subject the landlord to triple damages if deemed to have acted in a deceptive manner. Given that the landlord had not yet issued a refund, we drafted a demand letter on behalf of the entire group. We cited the statute that he had violated because we did not receive any refund offer or itemized list until 6 weekends later. When he sent a reply that we considered to be evasive, we filed in small claims court for our entire deposit plus treble damages and court costs. It is worth noting that I am inclined to be particularly irate when I perceive that someone is attempting to defraud me. In this case, it was evident that the landlord had made a career out of exploiting low-income tenants. It is likely that those who are unable to afford to fight this case will be unable to do so. I was extremely angry. I spent the following month before the court date gathering all of the email correspondence in which the defendant had made mistakes that had caused him to lose the case. These included providing documentation that he had exceeded time limits and charged the correct amounts. I also gathered phone records showing that the property had received numerous calls that were not answered or returned. I also documented the property manager's statements, which were often untruthful. I referenced the company's website to ascertain the CEO's role as legal counsel and used this information to construct a logical argument. I then printed the relevant statutes and highlighted the pertinent sections, creating 3 copies for reference. We created a comprehensive compilation of all relevant information, meticulously organized into 3 binders. One was for our reference, another for the property manager and/or CEO, and a third for the judge. Additionally, we presented a recording of the property manager admitting to the false statements he had made. The judge expressed amusement at our evident preparedness. He inquired if we were law students and subsequently awarded treble damages, court fees, and interest. I will never forget the CEO's expression when we looked over and smiled at him. His emails and disregard for the law were on the table. Rather than paying the original $350 or so from our deposit, he ended up paying us over $1,000. $300 a month later, the situation was resolved. However, I neglected to mention that the CEO filed a response to our lawsuit with a counterclaim for $1,220, expenses incurred as a result of the actions of the plaintiff, $5. The rationale behind this figure was not made clear, but in his final email before we initiated legal proceedings, he did state, "I hope we can avoid litigation in this matter, but we will engage aggressively if forced to do so." I was uncertain whether this story would resonate with readers, but it has been well received. Therefore, I am including my husband's final email to the CEO before the court hearing. In it, he displays a remarkable command of language, and I intend to read this email to you now. Mr. We will be filing a case in small claims court against the corporation you represent, namely, for failing to return our security deposit within 30 days at the end of the lease, and for failing to provide an itemized list of deductions within the same time period. This constitutes a violation of code such and so. In consequence of the aforementioned, the plaintiff is entitled to the return of the full security deposit, with no right to withhold any portion thereof. Furthermore, the plaintiff is entitled to sue for up to 3 times the amount illegally withheld, unless the defendant can demonstrate by a preponderance of the evidence that this was an accident. The plaintiff has presented evidence in the form of telephone records showing well over a dozen unreturned phone calls, as well as the fact that the check was not dated until the 6th of April, 7 days after the 30th. The aforementioned circumstances, including the failure to provide the check until 14 days after the deadline, the deduction of $200 from the deposit despite documented damages amounting to only $170, and the general lack of responsiveness to reasonable requests, demonstrate that this was not an honest mistake. Despite these violations of the law, we initially attempted to resolve the matter through alternative means. However, given the extent of the damages and the failure to meet our reasonable requests, we will now be pursuing legal action for the full amount of $1,420. The total amount sought in damages is $1,420. This figure is comprised of the following. 1. The $400 security deposit, plus the $75 refundable pet deposit, times 3. 2. The cost of certified mail, which is $18.91. 3. Interest on the amount owed, determined by date of judgment. 4. The cost of the legal process, estimated to be $85. It is notable that the parties initially attempted to settle the matter amicably and for a relatively modest sum. However, given the circumstances and the lack of a satisfactory resolution, the plaintiffs are now pursuing the maximum amount allowable by law. We will pursue legal recourse and seek the maximum allowable amount under the law. We have no intention of settling outside of court for any amount less than $1,425 plus all incurred costs. There is no need for you to contact us. Sincerely. Blank. In addition, the following observations were made. The condition list indicated that the screen was ripped and the carpet was in poor shape. Additionally, receipts were provided for 2 separate instances in which the screen was requested to be repaired upon the tenant's departure. A professional cleaning service was retained to assist with the cleaning process, and photographic documentation was obtained for both the pre-move-in and post-move-out periods. The tenants in question were a religious older couple who expressed strong religious beliefs. The office walls were adorned with religious iconography, which further exacerbated our already mounting frustration. When they refused to return our full deposit, we promptly drove to the property owner's corporate office and presented them with irrefutable evidence of their malfeasance. They had been engaging in deceptive practices, neglecting to perform the required repairs and retaining the deposits. The couple, who had adopted the surname Jesus Freak, were sentenced to 10 years imprisonment. They were encouraged to fight back and to take photographs as a means of revenge. If you enjoyed this video, you are invited to subscribe to the channel, as the number of subscribers is approaching 1 million. This will result in a special surprise being made available to subscribers at this milestone.